Hey, hey, hey! It's the first ever real estate marathon. I'm your host, Jas Takhar. Mr. Levitt, are you there?
How you doing? Can you hear me?
I can hear you perfectly fine. Thank you so much for being part of history today. It's the first ever real estate marathon. I'm not sure what time it is, like live time, but I feel like I've been going on for about 7 hours. I've been probably going on for about 7 hours. So we're going right through to 9 p.m. today, and your segment is very, very timely. We're going to be talking about the Bill 184, the new Bill 184. But Doug, why don't you just talk to my marathoners quickly about what you do before we get into the Bill 184?
So my background essentially is in litigation, commercial litigation. In that capacity, most of my clients are either landlords, developers, lots of condo corporations, real estate agents, brokers, people in the industry. We do at my firm a fair bit of residential tenancy law, a fair bit of commercial tenancy law, lots of development work, and lots of condominium law. So we're well-rounded in the real estate industry. And it's 360 for us. We do the transactional work, whether it's financing or deals, and we do the litigation. And so I sort of come in through the litigation dispute resolution part of the team.
Now, this new Bill 184, I know you've been going around the whole province, definitely in and around the Greater Toronto area, and talking about this Bill 184. What is it? How does it affect landlords? How does it affect tenants? Please educate us.
So, look, I think it's for the first time in the longest time, we've got a piece of legislation that's fairly balanced. I think both tenants and landlords benefit from these changes, firstly. There was and has been a lot of controversy around it, particularly from the tenant groups. I'm sure you've seen the news. People are climbing over Mayor Tory's house. Lots of angry disruptors out there. But there's nothing to be upset about. Nothing from the tenant side, and quite frankly, I think nothing from the landlord side. I think some of the highlights from a landlord's perspective include the following. Number one, in the old regime, landlords could not recover unpaid utility expenses at the landlord and tenant board.
Okay.
You couldn't go to the LTB. You could get rental arrears. You can get damages or compensation for disrepair costs to your residential complex, but you couldn't get utility costs. If you wanted to.
So Doug, if my tenant didn't pay the hydro bill, it was under his or her name, the water bill, me as a landlord, I could not get this back.
You couldn't get it back from the landlord and tenant board. In order to get it back, you had to go to the small claims court, which was difficult, not cost effective. One of the changes, which I think is notable, is that now you can get those utility costs back from the LTB. So you could bring your case to the very forum where you need to bring all of your other, I'll call it causes of action as a landlord, right? Whether it's rental arrears or whatever. Another big one for landlords is that under the old act, if you had a case against a tenant, you could only bring it to the landlord and tenant board when the tenant was in possession of the rental unit. And that was a big pain for landlords for a number of reasons. Now, even where a tenant vacates the rental unit, if you bring your application within the 1-year period that follows that, you can go to the landlord and tenant board.
So it's almost like a holdover period, so to speak, for that 1 year time after they've actually left.
It's a holdover period, and it's a holdover period that the tenants had. So in the old regime, tenants could take their former landlords to the court, to the landlord and tenant board. And if the landlord had, let's say, a counterclaim, former tenants are suing the landlord for something, and the landlord wanted to sue the tenant for something, they couldn't, because they couldn't bring their action at the LTB because the tenant was a former tenant. But now they can.
Perfect.
Another big thing is that now landlords can get damages or compensation for tenants that substantially interfere with their reasonable enjoyment. In the old regime, you were able to get an eviction order if a tenant engaged in bad behavior, and maybe if that bad behavior caused the landlord to suffer damages or costs, a landlord was able to get an eviction order, perhaps. In addition to that, now the landlord can get an order for compensation from the tenant. So that's a big one. And maybe the biggest, or one of the biggest, and one of the more controversial, is what I would call a Section 206 payment agreement. Okay. In the old regime, where a tenant fell into rental arrears, and the landlord brought a rental arrears application to the landlord and tenant board, whether to recover the rental arrears or eviction, and usually both, right? Where that application was initiated, a landlord and tenant were able, before the application was heard, to arrive at an agreement, a payment plan, to submit it to the landlord and tenant board before the hearing, and to get an order from the landlord and tenant board that required the tenant to pay the arrears pursuant to that payment plan. Okay. The remedy that the landlord had in circumstances where the tenant breached the payment plan was to reopen the application and then have a hearing. Now, in the new regime, landlords and tenants can agree to a specific special type of clause. We call it a Section 78 clause that says that where the tenant breaches the payment plan, a landlord can just apply to the board for an eviction without a notice, without a hearing, just straight to the board, and get an eviction order based on the breach itself.
And I can see why tenants have an issue with it.
Well, that's what the tenants have an issue with. And the answer to the tenants issue, and it's not a huge issue, although the landlord does get an order if the tenants breach, the easy answer to the tenants is don't breach.
Right. Pay your rent. Right. Yeah.
Of rental housing, but if you don't pay your rent and you do breach and an order of eviction is obtained against you, you as a tenant can still go to the landlord and tenant board and bring what we call a motion to set aside and stop the eviction from taking place so that you can argue your case for the board. So tenants still, even with this new provision in the legislation, they still have the opportunity to go to the board. The board always remains the gatekeeper for these eviction applications.
And is it safe to say the board always favors tenants anyways? With this new legislation, do you think there's been any type of swaying in the favor of landlords? And I'm not having a conversation with you that I'm all about let's protect landlords. I'm all about trying to find a fair scale, if that makes sense.
The legislation is interpreted as having a tenant protection focus, quote unquote.
Mm-hmm. Right.
That's right from the case law. So absolutely, and it's a remedial piece of legislation. That means it's been put in place to remedy an unfair balance of power. So to answer your question, yes, the scales, I would say, are tipped more in favor of the tenant. And at times perhaps too in favor of the tenant. But when we're talking about changes that I've seen in the 20 plus years I've been practicing, this recent group of changes is the most balanced that I've seen. And it makes sense given that it's coming from this conservative government. The changes right before with the Wynne government, that came in were, in my opinion, they were terrible. I don't think that they helped anybody. If I'm giving my opinion, I think it was one of these last-ditch efforts to get elected. I don't think it helped everybody, but it was clearly something that was designed to be tenant friendly and tenant centered, and it makes sense from a political perspective. There are more tenants that vote than landlords. It's the bottom line.
Now, for anybody who's watching and listening, you might have a current situation that you're going through. Please, email us at info@reccanada.com, and Tyler and Luke and Bobby and the rest of the team, specifically Tyler, will make sure that we get you in touch with Doug's team. I know this is what a lot of our REC insiders were asking for, was to find more out about the bill, the new bill, which is Bill 184. Now, Doug, is the Landlord Tenant Board open now? Like, are things running now? What's happening around all that?
There's a few things that are happening. It's a good question. There were two major, I guess I'll call it, events that came from COVID-19. One was there was this eviction moratorium that was put in place by the Chief Justice, an order that suspended the carrying out of residential evictions. So in order to evict a tenant, you have to get a Landlord and Tenant Board order. And once you have an eviction order, you can't just go ahead and change the locks. You need to file it with the court enforcement office. We call them the sheriff. Okay. And the sheriff has to carry it out. But there was an order in place stopping the sheriff from carrying those things out. Okay. And that order was just lifted, essentially. And now the sheriff, effective August 4th, has been scheduling and carrying out evictions. There is an appeal in the works. Landlords know about it. This is before the courts. There's an appeal that are being brought by certain tenant groups to put the eviction moratorium back in place. Okay. The hope is from these tenant groups is that they could get that eviction order, that suspension order back in place so evictions can't be carried out. That appeal and that proceeding is still pending. It hasn't been determined, but it's out there, and you should know that as a landlord. So that's number one. Number two, the Landlord and Tenant Board stopped hearing eviction applications and issuing eviction orders. That was the other thing that happened, big thing that happened in COVID. What I understand that's happening now is that the LTB is now scheduling these eviction applications and is in fact rendering eviction orders, but it ain't going to happen quickly.
There must be a massive backlog.
There was a massive backlog without COVID-19. I mean, that's the truth. They were way under-resourced there. They had half the adjudicators that they needed. They were running, I would say, somewhere in the neighborhood of 6 to 8 weeks before getting a matter heard for the first time. And many of those matters were adjourned. That was in December 2019. Right. Okay, we're sitting now and it's August 2020, and the backlog is just enormous. Even with them starting to hear cases, if they don't hire the people that they need there to hear the cases, then I can see eviction applications taking somewhere in the neighborhood of 6 to 12 months easily.
Is a good tip right now, or strategy, that if you're going through something in terms of needing to evict, like get it started or just get in touch with you and the team?
I was recommending you get it started during COVID even, because they were accepting applications. They weren't scheduling it.
Get in line.
The sooner you get in the line, the quicker it's going to get heard. And again, it ain't going to be fast. I don't want anyone to think this is going to be a quick process, but you got to start and you got to do it. The other thing you should know, actually, which is important, it's one of the changes, is that if you're bringing an eviction application for rental arrears that accumulated either in whole or in part after March 17, i.e. the declaration of the emergency, then one of the things that the Landlord and Tenant Board is going to consider before they order an eviction is whether you, the landlord, made efforts to mediate or negotiate a payment plan for the rental arrears situation. If you didn't make those efforts, 100% you're not going to get an eviction order. They're going to impose a payment plan. They're likely going to impose a payment plan no matter what. But for sure, if you didn't make those efforts, you have a problem.
We've been speaking about if issues come up and if we need repayment. I'm a guy who likes to think of things from the perspective of being proactive. What's some tips and strategies for our investors, our wannabe landlords, or landlords that are going to become, investors that are going to become landlords? What are some tips to not get into those situations while you're looking for tenants?
Clearly, with the rental arrears situation, I think it makes sense to try to work things out with your tenant. You want to get paid your rent. Presumably, they want to continue living there and should want to pay their rent as well. Trying to work things out now will help you at the landlord and tenant board, because if you don't, as I said moments ago, you're not going to get your eviction order. That's number one. I think you need to be, and this doesn't only stand for now, today, post-COVID-19, but it's pre-COVID-19. You want to move quickly when you have a problem or situation. There are a lot of landlords, particularly small landlords out there, that will try to work things out with their tenants and delay taking enforcement proceedings. And I think that's great. I think you should try to work things out with your tenants, but I think you need to do all of the above. You need to work both angles contemporaneously with each other. You got to work or try to work out things with the tenant, and you got to push forward at the landlord and tenant board. And the reason for that is, as I said moments ago, even in the best of times, the landlord and tenant board moves very, very, very slowly.
So now, Doug, but what can some of our guys like that are actually looking for tenants, like when they're writing up the lease agreement or going through the reference check, what's some tips from that perspective?
Look, you want to obviously underwrite the tenancies as best as you can. And I guess it depends who's doing that for you. Are you using a real estate agent, as many people do? And maybe many of your listeners are in fact agents as well, and investors. It's important that you do proper underwriting, that you check out their credit, that you check with former landlords, that you dot your I's and you cross your T's, okay? That's not a foolproof way to proceed. You still end up getting, sometimes good tenants have problems. They lose their jobs.
Sure.
There's lots of them out there because of COVID-19 that are struggling. I will say, though, that the data is in, and most tenants have paid their rent. Most tenants, despite having financial issues, despite COVID-19, have been meeting their obligations, at least in the city.
I've seen a number like 87, 88% of tenants that paid their rent during COVID. I don't know if you've come across numbers, if I'm wrong or if I'm bang on.
That is around the number I've come across, and that is less than it normally is, but not as it. Look, when March 17 came around, all of us, everybody that's listening, nobody knew what was going to happen.
Doug, I thought this was going to last 2 weeks. I told my team to take a little vacation. I thought the lockdown.
We didn't know if this was going to be The Walking Dead or if this was going to be a 10-day thing or what it was. I mean, who knew, right? The city, everything shut down. And so, there was this concern that there would be this terrible rent strike, and there are people still yelling about that, right? Look, from where we sit today, it hasn't been anywhere near as bad as all the alarmists thought in every respect, in every metric, okay? I think, this is my opinion, but certainly with rent. We're talking, I've heard 92% too, or 90%. I've got a lot of big clients. They're at the 95% mark.
That 87, 80, call it even 85%. I said 87 to 88, but say 85%. It actually coincides with the unemployment rate that we saw in the province, right? In the country, we saw about 15%. So it kind of made sense. I know it's a lot lower of people paying rent. We usually are seeing a lot higher, but it kind of made sense. I mean, people lost their jobs.
There were industries that were decimated from this, right? And a lot of tenants, unfortunately, came across terrible financial times, right? But still, because of the government supports, most people paid their rent. I mean, that's what's happened.
And so now, Doug, does your firm take care of also like looking over lease agreements? When does somebody get you involved? Or when should they get you and your team involved? I hope is there a way of getting you involved before there becomes any issues?
My group is sort of like special teams we come in when the what has hit the fan.
Got it.
And we solve problems. But there are other people in my firm that take care of things from the get-go. So we have my clients, when they're coming to buy a building or buildings, or they're selling buildings, will come to us, right? If, by way of example, there's a problem with the agreement of purchase and sale, the deals don't close, what hits the fan, it comes to me, and then we solve the problem here, and then we bring it back to the transactional guys. The same with the residential tenancy stuff. I mean, we do things from the beginning to end. As you know, in Ontario, there's a prescribed lease.
Yep.
So, we sometimes help landlords through that prescribed lease process, but you've got to use the government's lease. You can add additional terms, and we have sort of standard terms that we've created to assist our clients. So we help some of our clients with that. But that, for most of the larger guys, certainly that's sort of pro forma stuff for them. They deal with leasing and lease intake. Our smaller people will help.
Doug, we had a question. Is Doug a lawyer? Yes. The answer is yes. Is there a rent increase for tenant per the Ontario guideline? Right now for 2020, I believe it's at 2.2%. Is there any indications what it might be in 2021? I think it's too early to tell. Or when does that usually come through, Doug?
Yeah, no, I don't know what it's going to be. But, landlords have been able to take their rent increases through COVID-19. That hasn't been impacted at all.
Got it.
So,
okay.
And you know what? Most landlords, again, if someone were to ask me, I would tell most landlords they should increase the rent.
For sure.
Now, again, it doesn't mean you need to collect it right away. You could work something out with your tenants to work with them. But if you don't increase it, then you lose the right to increase it potentially, and you can't recover it. And increases are important because you springboard from previous increases, right? If I increase the rent in 2019 and then 2020 comes around and there's a new increase, I go from the old 2019 increased rent to the new 2020. And
you can't go retroactive. You can't go backwards. So you might as well do it year over year.
Yes, you can't recover. The same with above guideline increases. You want to take them when you can get them, because if you don't, you lose it.
Doug, I'm going to obviously have you on a long form podcast. We'll go much deeper into all things around landlords and tenants and how to be proactive. And when the hits the fan, what we can do. We're going to go long form. We're going to go 45 hour and a half, whatever it is. I want to thank you very, very much. I know how busy you are, but also I know you're spending some time with family, and you still gave me the 20 minutes and a little over. So thank you very much for your time. And for anybody who wants to be connected with Doug and his team, send us an email, info@reccanada.com. And Tyler Ty Walburn is standing by to set up those introductions. Doug, I'll reach out to you shortly. Thank you so much.
Thank you for having me.